Aside from eyewitness testimony, some of the most believable evidence presented in criminal cases in the United States comes from the FBI crime lab in Quantico, Virginia. Part of its job is to test and analyze everything from ballistics to DNA for state and local prosecutors around the country, introducing scientific credibility to often murky cases. But a 6-month investigation by 60 Minutes and the Washington Post last November showed that there are hundreds of defendants imprisoned around the country who were convicted with the help of a now discredited forensic tool, and that the FBI never notified them or their lawyers or the courts that their cases may have been affected by faulty testimony. The science, called bullet-lead analysis, was used by the FBI for 40 years in thousands of cases, and some of the people it helped put in jail may be innocent. One of them is Lee Wayne Hunt, who's now serving a life sentence in North Carolina for murder.
How long have you been here?
22 years, 6 months, and 5 days.
Did you do it?
No. But I'm said from the word get-go that I ain't never killed nobody. I didn't have nothing to do with this.
Lee Wayne Hunt was convicted in 1986 of murdering 2 people in Fayetteville, North Carolina, based on the testimony of 2 questionable witnesses and what turned out to be erroneous ballistics testimony from the FBI lab. For years, the FBI believed that the lead in bullets had unique chemical signatures, and that by breaking them down and analyzing them, it was possible to match bullets not only to a single batch of ammunition coming out of a factory, but to a single box of bullets. And that's what the FBI did in the case of Lee Wayne Hunt, tying a bullet fragment found at the house where the murders took place to a box of bullets the prosecutors linked to Hunt.
I'll put it exactly the way it sounded to me and the way I believe it to be. He said that this box of bullets is the same box of bullets was used to kill these people, made on about the same time.
I think everybody in the courtroom assumed that this was valid evidence.
Richard Rosen is Hunt's attorney.
How important do you think it was to your client's conviction?
I thought it was very important to our client's conviction. It was a single piece of physical evidence corroborating their story. And it came from the mountaintop.
The FBI first used bullet-lead analysis while investigating the assassination of John F. Kennedy, trying to match pieces of bullets discovered at Dealey Plaza with bullets found in Lee Harvey Oswald's rifle. By the 1980s, the FBI was routinely using it to link bullet fragments found at a crime scene with bullets found in the possession of a suspect, almost always in cases where more reliable ballistics tests were impossible.
Could you run like a standard ballistics test on these?
No, they're too deformed for the conventional ballistics examinations.
Bill Tobin, a former chief metallurgist for the FBI, says the Quantico lab was the only place in the country that did bullet-lead analysis, and the assertion that you could actually match a bullet fragment to a specific batch or box of bullets went unchallenged for 40 years, until Tobin retired in 1998 and decided to do his own study, discovering that the basic premise had never actually been scientifically tested.
FBI lab personnel testified that you could match these fragments to this bullet.
Yes, that's correct.
I mean, what did you find out?
It hadn't been based on science at all, but rather had been based on subjective belief for over 4 decades.
So what you're saying is that this is junk science?
That's correct. It's worthless as a forensic tool.
Tobin spent months buying and testing bullets and consulting with manufacturers, and found that bullets from the same batch weren't chemically uniform, that bullets from the same box didn't always match, and that it was statistically possible for every bullet manufactured in the U.S. to have tens of millions of twins.
Back in 2002, the FBI lab asked the National Academy of Sciences to conduct an independent review of comparative bullet-lead analysis. And 18 months later, its National Research Council came out with the report calling into question 30 years of FBI testimony. It found the model the FBI used for interpreting results was deeply flawed, and that the conclusion that bullet fragments could be matched to a box of ammunition so overstated that it was misleading under the rules of evidence.
Dwight Adams was the FBI lab director who commissioned the National Academy of Sciences study that ended up debunking decades of FBI testimony, some of which we read back to him.
Commonwealth versus Day. 2 bullet fragments found in Patricia Paglia's body came from the same box of ammunition. State versus Mordenti in Florida. It's my opinion that all of those bullets came from the same box of ammunition. Is that supported by the science?
Science never supported such a statement.
But this was the testimony that was given by people in the lab for 30 years.
I'm sure, as you have found, that is the case in some cases, but the science does not support that. This kind of testimony was misleading and inappropriate in criminal trials.
A year after the National Academy of Sciences study, Adams decided that the lab would stop doing bullet lead analysis, and the FBI notified police departments and the National Associations of District Attorneys and Criminal Defense Lawyers. The form letters, which underplayed the significance of the problem, said the lab still firmly supported the scientific foundation of bullet lead analysis, but questions had been raised about its value in the courtroom.
I've got a copy of the letter that you sent to the National Association of Criminal Defense Lawyers. Nowhere in here does it say that the testimony you've been offering for 30 years is no longer valid.
Well,
it's just not in this letter.
First of all, I don't believe that letter could contain testimonies regarding 100 or 200 or 300 testimonies.
This letter that you sent never specifically states that the testimony offered by lab personnel was wrong. It's just not in here. Yet you just acknowledged it to me. Why wasn't it in there? I mean, that's a headline grabber. I mean, that should be the first sentence of the release, shouldn't it?
This review was about the science of bullet lead analysis, and I determined, based upon that review, that it wasn't an appropriate technique.
Did you tell the Justice Department we have this problem and you ought to undertake a review of these cases?
It's not my position to tell the Department of Justice what they should and should not do.
Adams says he sent a memo to FBI Director Robert Mueller stating, "We cannot afford to be misleading to a jury, and we plan to discourage prosecutors from using our previous results in future prosecutions." But neither the FBI nor the Justice Department made an attempt to identify the cases in which flawed testimony had been given, or to notify the defendants, prosecutors, or judges involved.
I think it's a failure on the part of the lawyers at the Department of Justice to own up to a very, very serious error.
Barry Scheck is a director of the Innocence Project, which has helped free more than 200 wrongly convicted defendants. He says the Justice Department has a legal obligation to notify defendants about any information that might help prove their innocence, even after they've been convicted.
When federal agents come into court and testify to something that we now know was scientific error, that could be crucial evidence in serious cases, you've got to go in and make a serious, realistic effort to give people a chance to correct the errors. That's only fair. You can't even begin to talk about raising this issue on appeal if the people involved don't know it happened.
Only the FBI can identify the cases in which bullet lead analysis was performed, yet it has resisted releasing that information. So 60 Minutes joined forces with the Washington Post to see if we could find some of the cases ourselves. Our producers and Post reporter John Solomon worked with the Innocence Project and a team of summer associates from the New York law firm Skadden Arps, who conducted computer sweeps of electronic court files. We managed to identify 250 cases in which bullet lead testimony was a factor, and a dozen where it played a pivotal role in deciding the outcome. And that was after looking at only a small percentage of the total cases.
There's altogether something like 2,500 cases that the FBI analyzed since the 80s. There could be, 30, 40, 50, who knows, instances where people are wrongfully convicted.
A half a dozen defendants, like this North Carolina pastor who was accused of killing his son-in-law, have already won their freedom or a new trial by appealing bullet lead testimony. Others, like this Baltimore police sergeant convicted of murdering his girlfriend, and Lee Wayne Hunt, who you met earlier, are still in jail.
I never denied that I was a marijuana dealer in Cumberland County, but I'm denying that I've ever killed anybody.
We had fraudulent scientific evidence that the only concrete evidence that was used in this case, the only physical evidence, was bogus.
But Lee Wayne Hunt and his attorney Richard Rosen aren't the only ones who believe Hunt was wrongly convicted with bullet lead testimony. At a hearing in January, the case took a strange twist when Staples Hughes, the appellate defender for the state of North Carolina, came forward and revealed a secret that he had been keeping for more than 20 years.
The thing that makes this so terrible is that Lee Wayne Hunt didn't do it. That's what makes it so terrible. He didn't do it. He's not guilty.
You're sure of that?
Yes.
22 years ago, as a young public defender, Staples Hughes was representing Lee Wayne Hunt's co-defendant in the double murder that sent him to prison for life. Hughes says his client, Jerry Cashwell, told him in great detail shortly after he was arrested how he alone had committed the double murder. Lee Wayne Hunt, he said, wasn't even there. But because of the attorney-client privilege, Staples Hughes was duty-bound to keep the secret.
It was sort of one of those moments that stops you completely still. You know, my client saying, not only did I kill 2 people, but these other folks didn't have anything to do with it. The state's case is a lie. It's a fabrication.
Did you try and get him to tell that to the authorities?
No.
Because?
I'm his lawyer. It wasn't in his interest to have that known at all.
Because he could have been facing the death penalty.
Sure. Well, he was facing the death penalty. It wasn't theoretical.
Did this bother you?
It bothered me when Mr. Hunt was being tried. And it's bothered me ever since. There wasn't anything I could do about it. But I knew that they were trying a guy who didn't do it.
It wasn't until his client committed suicide in prison that Hughes felt he could come forward to tell his story in court. But instead of being commended for coming forward to clear an innocent man, the judge threw out his testimony and reported Hughes to the North Carolina bar for violating attorney-client privilege, even though his client was dead.
I'm not too happy to be in the position I am in now, but there's a guy in prison for something he didn't do.
It's impossible to know right now how many other bullet-lead cases like this may be out there in the netherworld of the criminal justice system. But Dwight Adams, the former FBI lab director who began to have doubts about the science, believes it's time for the government to reveal all of the information.
I don't believe there's anything that we should be hiding. I believe that everything should be made available in regards to the testimonies and the cases that were worked involving bullet lead analysis.
The FBI ultimately agreed, acknowledging that some of its bullet lead testimony was misleading and that it should have done more to alert defendants and the courts. As a result of the 60 Minutes Washington Post investigation, the Bureau has already reviewed nearly 100 cases, and according to the Innocence Project, there are problems with the FBI testimony in almost half of them. The complaint against Staples Hughes for violating attorney-client privilege has been dismissed, but Lee Wayne Hunt remains in prison after the North Carolina Supreme Court refused to hear his appeal.